And the defense rested. So you had 5 Jane Does that testified for the prosecution, plus all their other witnesses, about 29 total. 5 for the defense, very quickly on and off the witness stand. And now this is closing argument eve on closing arguments. Let me go back out to San Diego. Vikas Bajaj is with us, great criminal defense attorney out there. I'm asking a lot of the local attorneys about this, the pacing of this case. I don't know if years ago there was another football player who was on trial in California and it took like 9 months and there was the charge of murder. This one, 5 different accusers and things moved very quickly over the course of 2 weeks. Should we be surprised at the pacing of this trial?
It really depends on what's behind door number 2. Is there other forensic evidence out there? Are there other things that need to be tested? You can open up, go on Google, and you'll see that locally here there's an extraordinarily long backlog of DNA testing that needs to be completed here in San Diego for rape victims, sexual assault victims, and domestic violence victims. Now, the district attorney's office is going through their paces to make sure that catches up, but we don't know what else was out there. And this also dovetails into other witnesses, such as Mr. Vaughn that we talked about a bit earlier. We don't know what's behind door number 2. But let me just comment on the pace of this case in general, notwithstanding an exigent circumstance with DNA or forensic evidence and trying to avoid that from rearing its ugly head. This case has moved quickly. And I'll tell you, I try cases in this jurisdiction all the time. And this has just moved so fast. We're at barely about a year, I'd say, or around a year since the first arrest took place. You would expect that the investigation, both on the district attorney's side and the defense side, would have been a bit more well-developed, in my opinion.
All right, Lieutenant Colonel, what do you think about the investigation here and the pacing of it? I mean, very quickly from the beginning of Jane Doe number 1 to the trial.
I think it was rushed. There was really no sense of urgency to get a trial over with. You know, all the players are there. You have time on your side. So I think they should have taken their time. Certainly the prosecutor should have taken more time. And in the case of Mr. Vaughn, that should have been developed and ironed out way before they decided to start the trial. They should have had Mr. Vaughn in place, at least for a statement or something.
To figure out what may have happened there. Rachel, who gets the advantage now in this quick trial, quick to trial, and then the trial itself moving very quickly?
I hate to say this, but I think that the prosecutor sadly gets the advantage here. Again, it's easier to connect the dots when there's fewer dots to connect. Look at all these victims. They're not putting up extraneous random stuff to confuse the jury, and they're just saying, how could, basically, how could this be if he wasn't guilty? And so I think in making it quick, I'm sure it didn't feel very quick to the jury that sat there every day.
Right, they have no perspective. It's the only trial that they're probably sitting on. All right, so $50,000 GoFundMe page. The page, I believe, was taken down. She didn't get any money out of it, but that doesn't, I don't know. Ray, does this change the game at all? Does this now make the jury say, Jane Doe number 1, we don't believe you?
Well, I don't think so. I think that she responded to that question about what was the money for, I thought, very well. Of course, we're not in the courtroom, so we don't see all of her body language and facial expressions. It does, however, allow the defense, if they want to get into a money grab argument in closing, to at least have one piece of evidence so that they could say, well, when the state starts screaming, objection, objection, judge, she can say, well, Your Honor, the young lady said that's a money grab. It doesn't have to be for all of the witnesses. So at least allows them to inject that. And you saw that that was part of the defendant's media presentation. He said it many times. It's just a money grab. It's just a money grab. So that may be in the jurors' back of their mind as well.
I think that'd be more convincing had Jane Doe actually been the one to do it. The fact that the daughter saw Court TV and then decided, maybe I can get.
Well, no, she actually posted before she was ever on Court TV.
Oh, okay.
She testified that she posted the page once she knew she was going to testify, after she had spoken to the DA. Does that change your answer?
That's even stranger.
Yeah, I just don't think it has any evidentiary value. It allows the defense to maybe even get a charge that may say, and you can look at witnesses' financial incentives or motivations, witness or witnesses, and then try to spread it across all of the witnesses, which I think is not a great argument. But listen, when you're defending a case like this,
You gotta
and your
throw
client
everything out
doesn't
there.
take
But
the
at-
stand,
at the
you
end
got to
of
put some stuff up there.
At the end of the day, this is all about credibility now. You have victims that that may not be that credible. You have a superstar athlete who's from a lineage, you know, of superstar. His father was an athlete, Hall of Famer, and so that it's he said, she said. You have to look at that, and pretty much credibility is all the jury has to depend on. Is do we believe these people who two of them are homeless, one of them came forward,
16 years later.
16 years later. You have these other people, this other lady at the gym, you know, so there's no hardcore evidence except for that DNA from Jane Doe number 1. That's it.
Yeah, it's not a case with a lot of physical evidence. We're going to talk more about that coming up in a little bit. So let's bring back in the think tank as we talk about the scene of Jane Doe 1's alleged attack. Lieutenant Colonel, you're an investigator. What does it tell you about, what does the physical area, the scene tell you about Jane Doe number 1's version of what happened?
Oh boy, I'm really.
I don't like that reaction
Yeah.
if I'm a prosecutor.
Yeah.
If you say, oh boy.
As if I was investigating this and Jane Doe 1 was my victim, I would really start to doubt her. I really would. I would not be able to not doubt her based on where the fence is, the location from the fence to the restaurant, which tells me even if you walked and he was on the other side of that fence, you could probably make it at least to a point where someone would see you, maybe someone going to and from the restaurant, the parking lot, whatever the case may be. So I would really have to start to drill that victim without victimizing her again, of course.
Oh, absolutely.
When you have a rape victim, you have to be very careful on how you ask the questions because you don't want it to seem like you don't believe her. That's
stated.
one of the worst mistakes you can make as an investigator is to make your victim feel like she's not being believed.
But we're focusing on her running for help.
Right.
The speed of sound is faster than the feet of my legs. And she was within earshot of businesses, establishments, people going to their cars. Did she scream for help?
She
Did
jumped
she
over
yell
a
for help?
fence. This lady jumped over a fence when he was.
He went over the fence
And
first.
she's on the other side.
She's on the other side, and then
Go,
she
girl.
followed him onto the other side of the
It
fence.
doesn't look like an easy fence to just jump over. Meanwhile, if he's on the other side of the fence, he's naked. I don't want to be involved with him. I just walk away while he's on the other side of the fence. Did they count the number of seconds it takes to get over that fence?
No,
I mean,
no one tried to climb the fence itself, and that's another issue with all this is would he be able to climb that? Now he's 6'4", tremendous athlete. I'm sure he could climb the fence, but she said she also climbed the fence. Vic, let me go back out to you. Returning to the scene, that was a big part of the defense case, showing the jury these photos of the place where Jane Doe 1 says she was raped. What do you think about showing the jury that? Is that enough to raise a doubt about her story?
Well, I'll pick up a piece from your other guest there who astutely pointed out that it would raise serious credibility issues with the statement that was given by Jane Doe 1. You don't have to be a lawyer or an investigator or an expert to understand that this story is just odd. It's not 2 o'clock in the morning and you're jumping over a fence that is physically difficult to get over. Now, Mark Harlow's pointed out that the top of the fence did not have a ledge or something smooth on it, therefore leading to the allegation that it could cause a lot of injury. I'll tell you what I'd like to see, and I tell you what a lot of jurors would have liked to see. They'd like to see a dummy of Kellen Winslow's height, a dummy of the victim's height, and some sort of a demonstration on what kind of activity is actually required to scale that fence. We all know it's easy to climb a ladder. It's easy to jump up 10 or 15 steps. But to actually get your feet inside each one of those little chain links to then get yourself over the fence, it's borderline ridiculous as far as the factual description goes. Does that mean the rape did not occur? I don't know. I don't have enough evidence that the judge and the jury and the defense attorneys and prosecutors have combed through to reach that conclusion. I would tell you I would have loved to see a recreation. And maybe that's all part and parcel to how quickly this case has moved along, leaving those similar gaps throughout the story.
Now, something else that the investigator did, the private investigator for the defense, was to talk about the story of Jane Doe number 2. Now, her story is a little bit different. They're in the car and they take a drive down Manchester Avenue. And it's about a 4-mile ride altogether that she takes. And if we take a look at that video, they're going down this road. Now, this is shot during the daytime, but Jane Doe number 2 says it was at night when this drive was taken. And we believe that at some point on this road, according to Jane Doe number 2, they kind of do a turnaround U-turn somewhere and end up on one of the little side roads on the left-hand side of the screen that you're looking at. And the only thing that distinct that she remembered was a gas station, which you kind of see coming up on the right-hand side just before Highway 5. Now, the further testimony of Jane Doe number 2 is that after taking this 4-mile ride, he dropped her off on this road in the dark, and she ends up walking back about 3.5 miles back to where she came from, again, at night. And she said she was scared every time a car came by. She would hide from that vehicle. But you can see it's very... There's nothing here, but you come up after the highway, then there's some apartments on the right-hand side. All right, so how about this evidence for the defense, Lieutenant Colonel? What does it tell you about Jane Doe number 2's story, if anything?
Again, you really can't wrap your head around her explanation of what happened, how it happened. She's saying that she was dropped off in the middle of the night, correct? And she walked, I don't know how long, before she even tried to maybe get another person's attention, another passerby.
She purposely was hiding.
Right.
Her testimony was she was scared that he might come back.
Right. So, I mean, she knew what type of vehicle he was in. I mean, so wait till you see a vehicle that's not matching the description of his vehicle and try to flag someone down. I don't know. You can't really say what was going on in her mind. You know, fear is a strange animal. But she certainly would have had the opportunity, I believe, to get the attention of a good Samaritan, possibly.
I also want to show you pictures that the defense investigator has of the actual Hummer itself. And we'll take a look at this and see what sort of evidence or what this could potentially prove. Now, remember, the testimony in the case was that the attacks took place in the front seat. Yet in the front seat, there was no real forensic type of evidence found. There was some of his semen found in the back seat, which could have been from something else that happened in the back seat. I have no idea. You can see the back seat right there. But the front seat. Vic, in this case, you know, there's not a lot of the physical evidence. There was just enough to link him to both Jane Doe 1 and Jane Doe 2. But inside the actual Hummer, there wasn't really anything useful found for the prosecution, at least from my perspective. What are your thoughts about how the jury handles that? Because we all heard about the CSI effect, right? That the jurors' expectations these days are through the roof for this scientific evidence.
Well, I'm with you, and I think you hit the nail on the head. The expectations are through the roof, but I don't think you have to expect a lot to ask a district attorney's office or a police department to test the very seat where a vicious rape allegedly occurred. I'm a bit befuddled by that lack of evidence, frankly, without offending any of my local colleagues here. I will say, however, that this really dovetails into a belief that he has to testify, or he had to testify. We have physical evidence taken from the vehicle that there's no dispute he operated and was identified as a Jeep-type vehicle, but it was actually identified as the Hummer. There's no dispute about that the women were there and that was his car. So what's the missing link? Of course, there's a lot of opportunity risk calculations when a defendant or suspect takes the stand. But here, on balance, it's hard to convince me, at least, and I may be one on an island, but it's hard to convince me that there was that much detriment or danger in having Mr. Winslow Jr. explain consent. It would seem to be that DNA evidence would be, while lewd and lascivious and awkward or rare, explainable at that point in time.
Yeah, and Ray, the testimony also from Jane Doe number 1 was that she bled a lot.
Right.
They didn't find any blood in that front seat.
No, and let me disagree with my esteemed colleague out west. The reason that the defense wanted to sever these charges and the reason that the prosecution fought so hard to try them all together is because the prosecution doesn't have one really good case of the bunch. It's got a bunch of cases, each of which have got a whole lot of problems. And whether they're going to say it or not in closing, what they're trying to tell the jury is, come on, you might explain one person or maybe there was a misunderstanding, but not all these times. And that's why the defense wanted to try them one at a time and knock them out and knock them out, and also take those cases out of the similar transaction bad evidence menu by getting a not guilty or maybe a lesser included of a misdemeanor of some type. I don't know all that. So it's become evident as we worked our way through this tonight, especially with the lieutenant colonel here from the law enforcement perspective saying, hey, I'm not so sure. Well, he's the guy that's supposed to be sure, okay, and he's not.
You have to be confident in your case. When you put someone in jail, you have to be 100% confident. The last thing anyone in law enforcement wants to do is to arrest the wrong guy. That you wouldn't be able to sleep
I don't
at
know
night.
about that.
That's worst case scenario. Our
At least
13th
in
juror
my
question
case.
tonight, folks. Are you surprised Kellen Winslow II did not testify on his own behalf? Go to our Facebook page. We will reveal the results next. So that didn't happen today, but other things did happen. But who had a better day today? Was it the prosecution or was it the defense? Let's bring back in our think tank to get a verdict on today's proceedings. And we begin with Vikas Bajaj, who's out in San Diego, great criminal defense attorney. Who had the better day, prosecution or defense?
Well, it's the defense case. The defense had a better day. They were allowed to raise two important issues that may have some weight at the end of the day. That's Dennis Sesma's recreation of the route that occurred, which leaves a lot to be desired on certain parts by the prosecution, as well as a colorable argument that this is, in fact, a money grab vis-a-vis the witness testimony regarding the GoFundMe account.
All right, Rachel Kaufman, criminal defense attorney. Who had the better day, prosecution or defense?
I'm going to go ahead and agree with the defense. I think because it was their day to present evidence, I think that they got in the things that they wanted to get in to set themselves up for tomorrow, which is going to be their closing argument. And hopefully it will, I guess, rein it all in, and they'll be able to convince the jury that he's not guilty or that the state has not proven their case beyond a reasonable doubt. But today was a good day for them to have gotten some of those things knocked off their list that they're going to want to bring up tomorrow.
All right, Lieutenant Colonel Adam Lee, Assistant Chief Jailer, Fulton County, former Commander of Major Crimes at the APD. We see you from the first 48. Who had a better day, prosecution or
I
defense?
wholeheartedly agree with everyone that's spoken so far. The defense did a very good job of attacking the credibility of all of the victims. There was no one there that could come forward and say, this definitely happened. I have a witness here. Their questionable lifestyle. I even made note of, maybe the defense should have had the daughter come to court dressed a little better. That's one thing I would do. If I had a witness, I would have my witness come to court, not in a camouflage jacket. Jurors look at things like that. Jurors take note of what you look like, how you appear, and first impressions are very important to a jury.
All right, Ray Giudice.
Yeah, just on a note, I found myself trying to figure out what she had tattooed on her knuckles because I noticed that she sort of covered it up. I think the defense ended on a pretty good note, certainly not a bad note where they went home and had to soak their head in ice water. I think they've set themselves up, as pointed out, for a couple of very powerful themes in closing. And if they can win the case, it's in closing by showing all of the inconsistencies in the state's case in each witness, slice them up one at a time, and then argue what the government of the great state of California, the big bear on the seal, couldn't do this, couldn't do a forensic on the Hummer, couldn't recreate the fence scene, couldn't bring this fellow that says he was there during this sexual attack. They couldn't even bring him to court or explain why they couldn't get him to court. Did he pass away? Is he in China? Who knows? I think it's the state's fallacies that lend to the defense closing that you'll see tomorrow.
All right, I'm going to disagree with everyone. I'm going to say the prosecution, and the reason I'm going to say it is missed opportunity. Kellen Winslow II didn't testify. He could have testified. We've seen him speak before. This is someone who grew up in the spotlight, knows what it's like to have some pressure on him. And he didn't tell the jury he didn't do it. He didn't tell the jury it was consensual, which would have just added so much fuel to the closing arguments. I know there are risks, folks. I understand that. But all that bad information about him pretty much already came out, so I don't know how much worse it could get. So I'm going to say prosecution, but we'll see. Tomorrow, another big day. Let's check in with Chanley Painter to see what's coming up.
After 9 days, 35 witnesses, and 154 exhibits, closing arguments will be tomorrow. It'll be pivotal for both the prosecution and the defense. We can expect first thing to hear from Dan Owens, the prosecutor, as he will present probably a visual presentation of his case to the jury, explaining piece by piece, tying it all together. Then we'll hear from Mark Carlos on behalf of the defense team, arguing reasonable doubt, taking as much time as he needs to argue his case in front of the jury. Then after lunch, rebuttal. Dan Owens will have the last word for this jury, and then the judge will send the jurors off to deliberate. It'll be a big day tomorrow. You won't want to miss it, Vinny. We'll send it back to you.
All right, thank you so much, Chanley. And I want to go to my guest just one more time for one word, and it's all about closing arguments. That's the name of the show. We'll begin with you, Vic. Yes or no, can either side win this case with their closing argument?
Yes, the defense can and they must win it through their argument, yes.
All right, Rachel Kaufman.
Yes.
Yes.
Yes for the defense.
Ray.
It's defenses to lose, yes.
All right, folks. Fasten your seatbelts because our coverage continues here on Court TV. Closing arguments. That's why we named the show Closing Arguments, how important it is, how significant it is, and it's all going to happen tomorrow on Court TV Live. You're going to watch it here. You'll see it. I'll be steering you through it later in the day. Have a great night. Our coverage continues. Don't forget to hug the kids.